Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another episode of Legal Tea. Today's topic is a current trend, something going on in the current time that is pertinent to my little estate and elder law world. Today's topic involves assisted reproduction and how it specifically intersects with estate planning. And I'm sure you're wondering, how in the heck are you going to connect these dots, Jenny? And I'm sure that's not the first nor the last time you'll have that thought. Oh, I am, and I will. You just wait and listen. As always, let's get a little foundation under us first and talk about what I mean when I say assisted reproduction. According to the National Institute of Child Health and Human Development, assisted reproduction technology are, quote, treatments and procedures that aim to achieve pregnancy, end quote. A few of the most common assisted reproduction technology methods are first, in vitro fertilization, commonly referred to as IVF. Second, intrauterine insemination, commonly referred to as IUI. There's also third, donating sperm or eggs. Fourth, using a surrogate. And those are just to name a few. And I'm not going into what happens like scientifically with each, or medically maybe is the best word to use. How about I just leave that for the doctors and medical professionals to go into? So I read an article somewhere that basically said that assisted reproduction, the easy way to describe it, is essentially growing your family by any means besides sexual intercourse. Touché. So according to National Fertility Association, 1 out of 8 couples experience infertility issues. Therefore, as medical science continues to make progress, more and more of these couples may do assisted reproduction methods like the ones I just listed, IVF, IUI, etc. You know, I talked about this at the end of our last current trends episode when we were talking about cryptocurrency. That just like every other profession and field, the field of law is forced to change with the current times as well. So as in that cryptocurrency episode, I talked about how the legislature and courts are really starting to analyze and give us guidance on how to deal with cryptocurrency in the estate planning world. Well, they are doing the exact same thing in the assisted reproduction world. Courts are having to deal with this topic of assisted reproduction, so much so that I recently read an article in a magazine written for Indiana attorneys put out by our local state bar association. And it described it like this, quote, in all these cases, there are 2 competing interests, the fundamental right to procreate and the fundamental right not to be forced to procreate against one's wishes, end quote. And keep that in mind as we go through this episode, because that will make much more sense. Furthermore, they explain that there are more and more cases, and I'm going to guess across the country is what they mean by that, where courts have held that embryos are considered to be property, as are sperm considered to be property. And this is really important because what does an estate plan deal with? Someone's property. In fact, in cases, courts have held that both embryos and sperm could be divisible under an estate plan. Wow, interesting, right? Maybe just for me, I don't know. The next level to analyze here, according to the article, is whether there is anything in writing, specifically to see if there are any documents that state what the individual wants to happen with their property, aka the embryos or sperm, if something were to happen to them. So the article proceeded to share a couple of stories or examples of where things have gone a little sideways in this topic. First, it talked about a case in Texas where a couple passed away without any, quote, written guidance in any estate plan or fertility clinic consent documents for the disposition of their frozen embryos, end quote. The court got involved and the local probate court held that the frozen embryos were property and should be distributed to the couple's only heir, which was their 2-year-old son. And they further explained that on the 2-year-old's 18th birthday, he would have to determine the next disposition. What a strange ending. And then the other example the magazine shared was about a guy who was a cadet at West Point. And some of you may have remembered this. I sort of remembered it. Anyway, so it was a guy, he was a cadet at West Point, and he ended up dying in a ski accident. However, before he passed away, his parents obtained an order from the court to have sperm retrieved from their son. The magazine explains that, quote, further litigation ensued as to whether they could utilize the sperm to procreate, end quote. And what was their reason? Well, they wanted to use the sperm of their deceased son to continue the family name in accordance with Chinese tradition, as well as to preserve their son's legacy. The court actually held in their favor. And both of these stories really exemplify the importance of writing down what your wishes are with your property. If something tragic were to happen to you or to your partner, who knows what either of these parties in these stories would have wanted? And that's the problem. While I do not do family law, it's just not my thing, the magazine article shared that these issues are also creeping into family law as well. Like in a divorce, for example, many courts are yet again relying on what is in writing. Like, was there anything in the clinic consent form documents? Or did the parties execute a contract that, XYZ would happen to their property if a divorce were to happen? Or the magazine actually said in Pennsylvania, for example, a Pennsylvania court found that embryos were considered marital property and therefore subject to distribution through the divorce proceeding. So after successfully making our brains, maybe just my brain, explode, the magazine article really concludes by sharing that many fertility clinics do have language within their documents to designate what their clients want in the event a divorce happens or death happens. Though, in order to ensure wishes are appropriately honored, it's likely wise to ensure the documents held at the clinic and your estate plan state what your wishes are and that they say the same thing. That way, in the event that we have to put those wishes into action, there's no confusion or conflict. And what I mean by conflict is conflict between the clinic's documents and the estate plan. So if assisted reproduction technology is something that is pertinent to you, or is something that you may be interested in the future, or maybe you're just genuinely or generally interested in this topic and how it may affect you or a loved one's estate plan, we're going to talk about what you can do estate-wise to set your plan up in a way that ideally will deter things going sideways inadvertently. And give credit where credit's due, right? So many of these following ideas and tips are based off of a wonderful blog that I found from Thompson Law, PLLC, which is an estate planning law firm out of South Dakota. So let's dive in. Tip number 1. My friends, words are important, especially in an estate plan. What I mean by this is, how is the word child or the word grandchild defined in your plan? In our plans, for example, we often define child as being a lineal descendant of the client or adopted child. And sometimes we'll revise that definition depending on someone's specific circumstances. Though I can imagine some plans defining child as just a lineal descendant. What if you inadvertently disinherited adopted children or grandchildren, or children or grandchildren conceived with an egg or sperm donor, or children or grandchildren conceived via a surrogate? But what about words like descendants or issue or heirs? They're same issues, right? And maybe it's not really about inadvertently disinheriting, but what if the kids or grandkids don't get along? And then the kids or grandkids try to sue and claim that child shouldn't count as a beneficiary. Can they sue? I'll answer that really easily for you. Anyone can sue anyone at any time for anything. So sure. And then they'll end up using your estate funds in the most silly and stupid way. Tip number 2, get it in writing. Friends, us lawyers like things in writing. So remember those stories I shared earlier about the 2-year-old inheriting his parents' genetic material, and the West Point cadet, his parents retrieving sperm before he passed away? What would you want to have happened if you had genetic material stored and you passed away? We have to get it in writing. And some things to consider under this subtopic is what happens to your genetic material if you pass away, of course. 2, if you do want it kept, who should get it? 3, if you want it kept, do you want your estate to pay any expenses associated with storing or distributing it to whoever you do want to give it to? 4, if your partner or spouse is still living when you pass, do you want them to be able to still use it? 5, do you want your genetic material only stored for a certain period of time? And if that time has passed, do you want it destroyed? Donated? Obviously, there are many, many things to consider. Tip number 3, and this is our last one, check with your financial institutions that hold your assets, especially if you have beneficiaries designated on them. So what do I mean by this? Oftentimes on assets like retirement plans or life insurance companies or life insurance policies, you can designate a beneficiary or beneficiaries. You'll sometimes see a term of art called per stirpes or issue on those beneficiary designation forms. And these are just fancy legal words that deal with children and designating them as beneficiaries. You may want or need to call the financial institution or the life insurance companies, or maybe check with your financial advisor to have them check to see how these companies define child or deal with per stirpes. And I could see needing to explain to them why you're asking. Perhaps instead of listing just child or children or per stirpes, maybe you designate their names specifically because there's no confusion of your intention there. And these last 3 tips are just honestly scratching the surface. Time will pass. This episode will turn a year old, 5 years old, 10 years old. And maybe we'll look back and say, wow, that's all we were thinking about then. We were so naive. Like I said earlier in this episode, this topic is fairly new to my estate world, and we're still working on ways to support individuals and couples navigating their assisted reproduction journey. That is why it is so, so important to disclose something like this to your estate planning attorney. In case this episode gets old or this material gets old, and maybe laws have changed and gotten updated. And I get it. It may feel weird or inappropriate to tell your attorney, and I understand it's such a private thing. But at the end of the day, just remember we cannot do our job and protect you and your legacy and your estate plan if we don't know. So next week's topic is back to estate planning of the rich and famous. And on that episode, we're going to be talking about the lovely actress Elizabeth Taylor. Such a classic, right? And, last celebrity estate planning episode, if you remember, we talked about Farrah Fawcett, who had an awesome estate plan. So can we go 2 in a row? You'll just have to tune in to find out. So tune in next Tuesday, Legal Tea listeners. Talk to you then and stay well.